अरे गाडे हे घे, त्यांचं भाषण चालू आहे म्हणून आपण भाषण करतो.
Namaskar. A very good evening to all the respected members of Adhivakta Parishad, esteemed guests and luminaries. I, Soham Khambete, hereby welcome you all to this special lecture on registration of Waqf, organized by Adhivakta Parishad, Devgiri Prant. It gives me immense pleasure to welcome you all to this lecture. I am obliged as I welcome our today's keynote speaker, Advocate Srikanji Advant, Pranta Adhyaksha, Akhil Bharatiya Adhivakta Parishad, Devgiri Prant. President of today's program, Advocate Parijatji Pandey, former Mahamantri of Akhil Bharatiya Adhivakta Parishad, Vidarbha Pranta, and former President of Bar Council of Maharashtra and Goa, and Kshetra Sanyojak, Advocate Sanjeevji Deshpande, to this virtual platform and request their assent to begin today's program. Much obliged. It is an honor to introduce to you all our today's guest and Kshetra Sanyojak, Advocate Sanjeevji Deshpande. Advocate Sanjeevji Deshpande originally hails from Jalna. He has been a Sangh volunteer since childhood and has worked in Akhil Bharatiya Vidyarthi Parishad in college life. He has been a deputy editor in Lokmat Times for 2 years, and Sir is now a senior counsel in High Court and has also practiced at the District Court since 1989. Sir has worked as BJP Jalna District General Secretary along with other esteemed posts. Sir has been working as a zonal Sanyojak of Akhil Bharatiya Adhivakta Parishad for Maharashtra, Gujarat, Goa, and the western region of Daman and Diu. Sir has been writing various speeches on various topics, including today's Waqf and aligned registration topics. It is my honor to introduce to you all our today's keynote speaker, Advocate Srikanji Advant, Pranta Adhyaksha, Akhil Bharatiya Adhivakta Parishad, Devgiri Prant. Sir is a practicing advocate at Honorable Bombay High Court bench at Aurangabad, Chhatrapati Sambhajinagar for the last 36 years. He is a member of Management Council of the Manikchand Pahade Law College and Srimati Indirabai Pathak Women's College, established in 1956. Sir is the member of Academic Council at Maharashtra National Law University, Aurangabad, Chhatrapati Sambhajinagar, and Bhosla Military School, Nashik. Sir also holds the office of the treasurer at the prestigious educational institute Arya Chanakya Management Council. Sir, we are truly blessed by your gracious presence. I request you to please guide us.
नमस्कार. Parijatji Pandey, President of today's lecture, Sanjeevji Deshpande, Senior Counsel, Mahamantri, and other office bearers of Adhivakta Parishad, Devgiri Prant, and all the esteemed Adhivaktas. Today I am assigned with the responsibility of speaking on the registration of Waqfs. The subject is concerning to our property rights and needs to be conveyed to the public at large for their benefit. Generous Muslims, adhering to the principles of endowment enshrined in Islam, often bequeath large and valuable portions of the properties in the name of Allah. The usufructs from these properties is dedicated to meet the exclusive needs of the poor and also for the perpetual maintenance of the property so bequeathed. The doctrine of Waqf is so intrinsically interwoven with the religious and social economy of the Muslims that it has become one of the most important institutions of the community. However, many of the existing Waqfs have shown a steep decadence caused largely by neglect misuse, and hordes of mismanagement, resulting into increased risk of more and more properties of individuals being claimed to be work properties without any proper procedure or documentation. The concept of waqf denotes permanently donating movable or immovable property by any Muslim person in the name of Allah for being applied for religious or charitable purposes. The waqf is irrevocable as the gift under the Transfer of Property Act. Such an endowment is analogous to the creation of a private trust under Indian Trust Act. No fault can be found with the notion of donating a movable or immovable property for religious or charitable trust. But the issue is otherwise as regard the legal entity into which such properties vest perpetually and are being administered. The nature of property, its acquisition by the donor, the legality of his alleged title to the same, his locus standi to donate, and the like considerations are hardly put to scrutiny before they are received and registered as work properties with the Waqf board. Thus, the validity of the alms made by any person many a time raises a question mark. One more aspect of the matter is that a donation so made when it involves immovable property is not affiliated to and reflected in the revenue, statutory, or any other ancient record prepared and maintained by the state. The fact that a work is registered with the state work board is no more answer to such serious issue. It is because it amounts to running two parallel institutes for monitoring the properties gifted, donated by the persons belonging to different religions. Another side of the coin is that for administering any Hindu public religious or public charitable trust, irrespective of its size, a board of trustees is constituted so moto by the trust or under the scheme which may be framed in that regard by the charity commissioner. Moreover, every trust so constituted is accountable to the charity commissioner for its functioning and administration. Friends, however, in the utter contrast with this scenario, all the work properties are administered by the State Work Board, which consists of nominees of the state government and a few Muslim scholars and a few other individuals. It is astounding to find that such a small number of persons whose status is analogous to the trustees are entrusted with the task of administering the immovable properties which measure in thousands of acres and are spreading over and lying across the nation. This is physically impossible and has every potential to defeat and frustrate the sacred origin and pious purpose of the Waqf. So also it is highly irrational to find that no dispute regarding any work property is amenable to the jurisdiction of civil court or any revenue authority under revenue laws. Not only that, such disputes can be addressed exclusively by the work tribunals, which are meager in number, to cater to the needs of proper and effective adjudication of such controversies. It is no surprise that the work tribunal in Maharashtra is invariably manned by Muslim personnel and no person belonging to any other religion has an opportunity of nomination as a member of work tribunal. Therefore, the work board, instead of being the trustees of the endowment made by the common Muslim, virtually turns up as the owners of such properties and enjoy unlimited domain and unbridled power over the same. In effect, the Muslim personnel become the judges of the cause of Muslims. This is clearly not in tune with the principles of natural justice. It is a case where we find that on one hand, a donor is rendered an alien to the property he has donated, while on the other hand, the members of the work board who are alien to such property are vested with the absolute domain over the same. This anomaly needs to be cured and set right forthwith. Waqf means the permanent dedication of movable or immovable property for the purposes enshrined in Islam as pious, religious, or charitable. The administration of the Waqf institutions are entrusted to different entities at different times in India. During the Muslim rule in India, the Waqf administration was decentralized and controlled by provincial and district officers such as Sadar-e-Suba, Sadar-e-Sarkar, and Khazis. There was also a separate department to look after the religious endowments such as Aywan-e-Mazhabi or Umrur-e-Mazhabi. The history of statutory administration of Waqfs can be studied across three periods. The period of non-intervention from 1765 to 1863, the period of partial intervention from 1863 to 1923, the period of legislative efforts from 1923 to 1954. The statutory administration of Waqfs can be traced back to the year 1765. This period saw the dawn of British administrative control in India. From the very beginning, the British adopted a policy of non-interference so far as the personal laws of the Indians were concerned. It felt disinclined to foist English ideas on the people who were not used to them. Thus, for a while, East India Company did nothing to interfere either in the administration of Waqfs or trust that continued to run on the similar lines as under the Mughals. The British Crown considered it appropriate to provide for an equal and impartial protection of law without making any special provision for its management. In furtherance of this policy, the Religious Endowment Act 1863 was passed. As a result, the land and other properties relating to mosques, temples, or other religious endowments which were under the management of the Board of Revenue were transferred to the trustees, managers, or superintendents, and local committees were appointed to exercise the power of board revenue. The Act of 1863 unburdened the government officers from directly governing the native endowments. As a result, the following consequences ensued. Regulation of the Bengal Code, regulations of Madras Code were repealed. The Act of 1863 was then applicable only to public endowments. The government was divested of all its responsibilities of managing the native endowments. Endowed properties were transferred to the trustees or managers, and local committees were constituted in accordance with the wishes of those interested in maintenance of such institutions. The jurisdiction to try all disputes relating to Waqfs were then conferred on the district courts. However, this step did not bear much fruits. The most important reason for its failure was the abolition of the post of Qazis and Pandits, who were earlier appointed to assist English judges in the matters of personal law. Thus, the Act of 1863 put the affairs of the Waqf in a greater mess than it already was before the passing of the Act. All the systems of checks and balances had given way. There was growing dissatisfaction over the government policies and a widespread urge to amend the Act of 1863. As a result, several bills were introduced in the councils and the Council of the Governor General of India. Later in 1890, the Charitable Endowments Act 1890 was enacted for the administration of public endowments of a non-religious character. The Act provided for the appointment of a treasurer of charitable endowments for whole of the country. It further provided that the administration of trust can be vested to the trustee provided a request is made by the appropriate person. In 1908, I repeat, in 1908, the Code of Civil Procedure was enacted. The provisions were made in this code by virtue of Section 92 and 93 to prevent the maladministration of the works, but this step made the administration of the works more cumbersome in more ways than one. By the turn of the century, dissatisfaction gave way to the agitation. There were recommendations, representations, and resolutions from every corner of the country. Thus, the government was forced to abandon its old policy of non-interference, and the Waqf Validating Act of 1913 was enacted. The first piece of legislation exclusively on Waqf was Mussalman Waqf Validating Act 1913. This act validated family waqfs without retrospective effect. All the regulatory and supervisory enactments referred to above were of general nature, governing endowments of every community and having limited scope. As these acts had failed to curb malversation, the Mussalman Waqf Act 1913 was passed to make provisions for the better management of the Waqf property and for ensuring the keeping and publication of proper accounts. Section 3 of the Act of 1913 made it mandatory for Mutawalli of every Waqf to furnish to the court a statement containing the particulars of the Waqf as the description of the property, income, and expenditure. It provided for penalties for furnishing false accounts. However, the Act suffered from few drawbacks. It relied heavily on the civil courts in all matters, which failed to strictly implement its provisions due to scarcity of time. It did not confer any authority on the court to direct a mutawalli to file a statement of accounts. It did not lay down a remedy in case of holder of the property denied its waqf character. After the representation to the British Crown, the Mussalman Waqf Validating Act 1930 was enacted, which accorded retrospective validity to all family waqfs and extended it to whole of the India. The Mussalman Waqf Act 1923 left the dispute resolution mechanism to civil courts, which have formulated the scheme of administration for some of the Waqf institutions. Now, with this, I'll be taking you to the provisions of Bombay Public Trust Act. Justice Tendulkar Committee recommended the government of Bombay to enact a comprehensive law with Charity Commissioner holding central role in implementing the policy on the lines of British Charity Commission. Emerging from this background, Bombay Public Trust Act 1950 had the objective to regulate and to make better provision for the administration of public religious and charitable trust in the state of Bombay. Section 2, subsection 13 of the Bombay Public Trust Act defines public trust as an express or constructive trust either a public, religious, or charitable purposes or both, and includes a temple, a mutt, a waqf, a church, and other places of public religious worship, a dharmada, or any other religious or charitable endowments, and a society formed either for a religious or charitable purpose or for both, and registered under the Societies Registration Act. The definition of the public trust has a wide ambit to reach out all the institutions and places of public worship amidst all the religious communities wherein features of public trust are prevalent. The secular and all-inclusive approach is notable. Although the term trust is not defined under the Trust Act, Bombay Public Trust Act, drawing analogy from the Indian Trust Act and other prevalent laws, the requirement of element like obligation attached to the ownership of the property, confidence reposed and accepted by the owner, declaration for the benefit of another and for oneself and another are the essential even for public trust. Dedication of property for religious or charitable purpose being the cardinal factor is inferred from evidences and the conduct of parties about the way of acquisition, retention, purpose, and treatment of the property in case express trust deed is not available. On common characteristics of public religious or charitable bodies is their orientation and the inclination to promote socially useful objectives. Regarding religious purposes, the permissibility is decided on the basis of the practices of religion, whose social side or humanitarian approach counts a lot in this regard. About charitable purpose, there is a detailed provision under Section 9 of the Bombay Public Trust Act. Since the meaning of charitable purpose is vital for identity and functioning of public trust and also to the reach of command and control model. The process of registration under the BPT Act is governed by Chapter 4 thereof. Registration of the public trust is a means of establishing jurisdiction. Registration enables the establishing a repository or authentic database regarding all public trust. It systemizes the document keeping process and authenticates changes in accordance with the procedure. Chapter 4 of the BPT Act gives elaborate provisions about the registration of the public trust. The legal arrangement for registration of the public trust aims at mandatory registration of all eligible public trust with due observation of fair procedure. There are 5 ways through which registration of public trust occurs. First, by virtue of deeming provision under Section 28 of the BPT Act, all the public trusts registered under the existing laws in Schedule A shall be regarded as being registered under the BPT Act. Section 22B of the BPT Act, the properties of the public trust shall be entered in the register. Second, the registration process starts with application submitted by the trustee of the public trust, who is duty bound under Section 18 to register within 3 months from the creation of the trust or from the date of commencement of the Act in case it is created earlier. The failure to perform this duty is punishable with fine under Section 66 of the Bombay Public Trust Act. Thirdly, upon an application made by any person having interest in a public trust, the registration process commences. Fourthly, the Deputy or Assistant Charity Commissioner on his own motion may initiate registration process by going ahead with the inquiry for registration. Fifth, a public trust may be created by will, wherein the executor of the will shall make an application for registration within 1 month from the grant of probate or within 6 months from the date of testator's death. The inquiry to be conducted by the Deputy or Assistant Charity Commissioner while attending the second, third, and fourth circumstances enumerated above is a quasi-judicial function and shall conform to the board, if not rigid principles of natural justice. Since a suo motu inquiry under Section 19 combines with the roles of investigator, prosecutor, and judge in Deputy and Assistant Charity Commissioner, they shall employ the service of inspector and shall act objectively. As per Section 73, officers holding inquiry possesses the power of civil code and giving of public notice of holding inquiry is mandatory under the law. This opportunity of community participation makes the process socially involving. The question as to whether the author of the trust had the right to give the property is not within the purview of Section 19, although the Deputy or Assistant Charity Commissioner may incidentally inquire into the matter and hence civil court jurisdiction is not barred. Regarding the question whether any property is a property of the trust, Bombay High Court's view is in favor of allowing jurisdiction of civil court since the Act does not provide remedy to the parties who are not parties to the inquiry. The power of the Charity Commissioner to inspect, supervise, and inquire is another control mechanism. The charity commissioner, the deputy charity commissioner, or assistant charity commissioner, or any other authorized officer has the power to enter and inspect or cause to be entered on and inspected the trust property, to call for and inspect proceedings, books of account, or documents in possession of the trustees or other persons connected with the trust, to call for statement of account or report, and to get explanation from the trust or the persons connected with the trust. The charity commissioner, deputy charity commissioner, or assistant charity commissioner may either suo motu or on the basis of the complaint by any person having interest institute an inquiry with regard to the charities or a particular charity or class of charities either generally or for a particular purposes. The inquiry officer has the power of collection of evidence, administering oath, and summoning attendance and documents. The report shall be sent to the charity commissioner with remarks thereon. The charity commissioner shall take such steps as are necessary under the provisions of the Act in response to the report. As orderliness and systemization in the matters of collection, use and protection of income and property are crucial for good governance of the trust. They are to be ensured through instrument of discipline, both moral and legal. Further, there are distinguishing features which differentiate a trust from a waqf, which are: a waqf is a perpetual and irrevocable, whereas trust need not be perpetual, may also be revoked under certain conditions. A waqf property is inalienable, whereas the trust is free to alienate the trust property. The founder of a waqf cannot reserve any benefit for himself, but the founder of a public trust may himself be a beneficiary. The powers of a mutawalli, manager of the waqf property, are very limited as compared to the powers of the trustee. Now with this, I have given the real picture in relation to the enactment of Bombay Public Trust Act. So this was till 1950. Now after the independence, it was considered appropriate to have a separate body for governance of the waqf institutions at the state level. The Waqf Act 1954 was enacted, which provided for incorporation of Waqf Board at the state level and a Central Waqf Council at central level. The Waqf Act 1954 was amended several times to cope up with the emerging challenges. Section 69 of the Waqf Act 1954 deals with repeal and savings, according to which the enactments of 1863, 1890, 1920, and 1923 have been repealed. The Waqf administration was falling into decadence. It was therefore felt necessary to have a comprehensive piece of legislation for the effective administration of Waqf institutions in the country, which resulted in the introduction of Waqf Act 1995, and all the previous legislation in this regard were repealed. The existing Waqf Act 1995 came into force on 1/1/1996 by repealing the Waqf Act 1954 and Waqf Amending Act 1984. Bare perusal of the provisions of the Waqf Act 1995 reveals that crucial legal and constitutional aspects were not accounted for. Various provisions have been consciously omitted by giving send-off to the constitutional ethos, values, and rights of all the citizens. The legislation is problematic of many fronts. Firstly, administrative, political, financial, and economic implications seems to be nonchalantly ignored by the drafters of this law, as no thought has been spared for the grave implications on property rights and their enforcement in the light of the provisions for dedication of property to the Waqf. The said legislation also betrays a sense that the opinions of the constitutional experts and other important stakeholders have not been accounted for. Further, the legislation has given undue importance to the aspects of dedication of property towards Waqf. The person eligible to dedicate a property to Waqf and also the rights of minorities within the Muslim community itself. Land being a state subject has also been dealt with in a cavalier manner in the scheme of the Act, as the provisions reflect a rather liberal regime for the dedication and enforcement of Waqf rights. The wording and phraseology employed while drafting the Act has resulted in an overboard legislation extremely expansive, unjust in its scope. Various contentious provisions of the Act of 1995 make one wonder whether they have been put through the rigors of legislative process and whether they have been considered thoroughly. Instances of overriding powers to the survey commissioners and half-baked provisions providing for publication of the list of awqafs, but not providing for any opportunity for hearing to the affected persons due to the proposed dedication are proof enough that the legislation fails on the anvil of the reasonability. The Waqf Act 1995 suffered substantial amendments on 20th September 2013 by way of Waqf Amendment Act 2013. However, the Amending Act of 2013 could not ensure better administration, and there were several shortcomings, which compelled the Government of India to introduce Waqf Amendment Bill 2024 on the floor of the Lok Sabha. Upon deliberations by the members of Lok Sabha, the bill has been referred to a joint parliamentary committee JPC, especially constituted for scrutinizing the bill. The JPC shall present its report in the interim, and the bill is scheduled to be tabled again in the Lok Sabha in the next session of the Parliament. It is pertinent to understand the changes proposed to be brought in by the Waqf Amendment Bill 2024. The changes are proposed for achieving the objective of better administration, effective management, empowerment and development of the Waqf properties under the Act of 1995. Clause 18 of the bill proposes a condition under Section 36 of the Principal Act that execution of a Waqf deed, I repeat, the execution of a Waqf deed is necessary for the institution of a fresh Waqf. The bill insists on a database and portal that do not exist. The powers of the state government and the state Waqf boards are undermined, and the powers of the central government are consistently insisted in the bill, which is a welcome step. The district collector and district magistrate is assigned a greater role, restricting the authority of Waqf boards in the matter of registration and surveys of Waqf properties. Registration of Waqf is mandatory under Section 36 of the Waqf Act. Application for registration of the Waqf shall be made by Mutawalli under Section 36(2). If the Mutawalli fails to register the Waqf, and as per Section 36(7), on the receipt of the application for registration, the board may make such inquiry as it thinks fit in respect of the genuineness and validity of the application and correctness of any particulars as and when any application is made by any person other than the person who administers the Waqf property, and the board shall give notice to the application to the person administering the Waqf property and shall hear him. As per Section 36(8), in case of Waqf created before the commencement of the Act of 1995, every application for registration shall be made within 3 months from such commencement, and in the case of Waqfs created after such commencement, within 3 months from the date of creation of the Waqf. Now with this, I need to inform you, the Honorable Supreme Court in the matter of Maharashtra State Boards of Waqf versus Sheikh Yusuf Bhai Chawla has decided a case which I will term it as a locus classicus and primarily deals with whether trusts registered under Bombay Public Trust Act 1950 are to be treated as Waqf under the Waqf Act 1995. Determination of the Waqf property, we are really concerned with para 167 of the said judgment, which says when the board has any reason to believe that any property of any trust registered under Indian Trust Act 1882 or any society registered under Society Registration Act 1860 or the property of any trust registered under any of registered under any other law is a work property, the board is given certain powers and responsibility. The board is clothed with the powers notwithstanding anything contained in any of those laws to hold inquiry in regard to the said property. The said property must be understood to be a property of any trust which is registered. The holding of the inquiry is to be preceded by a notice of the proposed action to be given to the authority by whom the trust or society has been registered. It is not to be confused with the trust or the trustees. It means that the work board must give notice of the proposed action to the charity commissioner, as it is the authority under section 1950 who registered or registers a public trust under section 18 of that act. Section 40 contemplates that the board, if it is satisfied that the property is a work property, shall call upon the trust to either register such property under the act as work property or to show cause why such property should not be so registered. In the first limb of this clause, an impression may be gathered that the trust or the society can be straightway directed to register the property under the act and there is no need to issue any notice to them. Now I'll be requesting to kindly consider the proposed section 3A of the bill, which states that only a person practicing Islam for at least 5 years may declare a waqf. This is very important provision which is sought to be introduced by way of amendment. It further clarifies that the person must own the said property being declared and section 3A removes waqf by user. We are really confronted with the situation in many matters. Person interested takes up a cause, takes a claim by waqf by user, and to overcome the said issue which is created by the persons interested, we need to and we are putting in all sincere efforts to demolish the case which is brought in by the person interested. But while doing so, a gigantic claim, a gigantic the gigantic claims are required to be pierced by putting on record all the necessary documents, pre-independence document, post-independent document, and the documents which are really prepared, maintained by the revenue authorities, and so on, so on. So I also request you to kindly consider section 4.1 of the bill, which is proposed to be substituted by virtue of which any pending survey of the Awqaf before the survey commissioner shall be transferred to the collector and the survey shall be made in accordance with the procedure in revenue laws of the state from the stage such a survey is transferred and the report shall be submitted to the state government. This is a very important decision taken by the state. We all know as to how The survey reports are prepared and those are submitted to the competent authority under the Act of 1995, and those survey reports are creating innumerable problems in the vested right or the property rights of the persons. Now, with this, I also urge to kindly consider Clause 6 of the bill proposes to add two subsections after Section 5.2, namely 2A and 2B. I will look to when we consider Section 5 of the Act of 1995, we see two subsections after Section 5.2 are sought to be inserted. These subsections provide for uploading the notified list of awqafs on the portal or the database within 15 days from the date of publication in the official gazette. This is also a very important step which is taken by the government in asking the authorities to upload the notified list of awqafs on the portal or database. Then subsection 2B provides for the constituents of the details of work such as identification, boundaries of the work properties, their use, occupier, details of the creator, mode and date of such creation, purpose of work, and their present mutawallis and management as provided by the central government. Section 5.3 also proposes to be substituted, and a new subsection proposes that revenue authorities, before deciding on the mutation of the land records, shall give a public notice of 90 days in two daily newspapers circulating the area, and also give affected person an opportunity of being heard. In line with the aim of greater digitalization and transparency, a Waqf management system or any other system set up by the central government for registration and accounts for registration and accounts audit and any other details of the work and the board as may be prescribed by the central government. This section proposes that every work registered under the Act shall file the details of the work and property dedicated to the work on portal and database within the period of 6 months from the commencement of Work Amendment Act 2020-24. Section 3C is newly proposed. The bill seeks to provide that any government property identified or declared as work property before or after the commencement of this act shall not be deemed to be a work property. The bill further proposes that if any question arises as to whether any such property is a work property or not, the collector having the jurisdiction shall make an inquiry as he deems fit and determine whether such property is a government property or not, and submit a report to the state government. It further provided that such property shall not be treated as a work property till the collector submits its report to the government. If the collector returns the finding that the property is a government property, then a report shall be submitted to the state government with the recorded findings. Subsequently, the state government shall direct the board to make the appropriate corrections in the record. The power to make a decision about whether a property is a government property or a work property will now be made by the collector and not by the tribunal. This is a very important decision taken by the government, and based on this decision, I hope and trust half of the litigation will be over. Now I request you to kindly consider Section 36 of the Waqf Act. Section 36 of the Waqf Act deals with the registration. Subsection 1A proposed to be inserted, which reads as follows: on and from the commencement of the Waqf Amendment Act 2024, no Waqf shall be created without the execution of a Waqf deed. So this is a prima donna consideration which is required to be borne in mind while taking the call under Section 36 of the Act of 1995. Subsection F is also proposed to be substituted to the effect that power to prescribe any other particulars necessary for registration shall be given by the central government and not the board. New subsection 7 proposes that power to make inquiries rest with the collector. Then section 7A is also sought to be inserted in section 36. It proposes that when a collector mentions in his report that a property, either wholly or in part, is a disputed one, then the Waqf for that portion shall not be registered till the matter is decided by a competent authority. This is also a very important decision taken by the government. Till the adjudication or the culmination of the said proceedings, finally, by a competent authority, the said property cannot be termed to be a Waqf property, or any stake which is claimed, asserted over the said property will not be adjudicated Subsection 8 and 9 are proposed to be newly inserted for providing certificate of registration through the portal and a limitation for filing cases regarding the Waqf not registered in accordance with the Act. A period of 6 months has been provided after the commencement of the Amending Act 2024. Section 40 of the Act of 1995 is proposed to be deleted in its entirety. From the above amendments, it is manifest that the Center has taken a proactive step to cast a statutory obligation on the person practicing Islam and owning a property who intends to create a Waqf to go through a substantive process and follow the rule of law while registering the Waqf. This step would surely check the misuse and abuse of the fraudulent claims of the Waqf being staked by unscrupulous elements with an ill motive to usurp the property and to cause harm and injury to the right of an individual. We need to ensure that, I repeat, we need to ensure that the bill passes through the rigors of debates and finally results in a legislation of 2024. With this, I conclude and I say thank you very much. Thank you very much.
Thank you, sir, for presenting such a poignant and harsh reality as we understood the responsibility cast on us as the members of Adhivakta Parishad on today's topic, that is registration of Waqf. We are highly obliged by your valuable guidance. And now, I have been entrusted another responsibility of introducing to us our today's president, Advocate Parijat Madhusudan Pandey, sir. Sir has completed his education in BSc and holds a master's degree in law. Sir has been a practicing advocate since 1999, and he has been working devotedly as a member of Akhil Bharatiya Vidyarthi Parishad till 2010 in his years as a student. He has been an active member of the Akhil Bharatiya Adhivakta Parishad and has held various important positions along this journey. Sir was elected as the member of Bar Council of Maharashtra and Goa in 2018. And Sir has also held the prestigious position of the President of Bar Council of Maharashtra and Goa. Sir, I request you to please deliver the presidential address.
Namaskar. Honorable Sanjeev ji, our beloved Zonal Secretary, Advocate Shri Advan sir, President of Devgiri Pranta, who is like guardian to me, Advocate Sangeeta Tai, General Secretary of Adhivakta Parishad Devgiri Pranta, and all the Karyakartas from Nandurbar to Nanded and from Parbhani to Dharashiv. Namaskar. In the beginning itself, I express my gratitude towards organizers who have given me opportunity to have a word, to have a dialogue with all of you Karyakartas. Friends, nowadays, these 4 letters, WAQF, work, has become a hot topic across the nation. Many people are making hue and cry over these amendments proposed by the central government. They are making such a hue and cry that the amendments proposed by the central government are of such a nature that everything will be come to an end. After this bill is passed, everything will be finished. Is it so? Certainly not. Are these amendments are direct interference in worshipping any particular faith? The answer is again no. Then why these people are making such hue and cry? See, what we have to do if any person is following any particular faith like Islam, donating his or her property in the name of religion. Someone can say it is between him and his religion. No, answer is again no. This matter is certainly not between a person devoting his property in the name of his religion, in the name of his faith. Because after listening to Advan sir, it can be clearly understood that all the limits have been crossed in all these years. By taking undue advantage of legal provisions which are in existence today, any property can be shown in the name of work. Even a common Muslim is suffering due to all these provisions which are in existence in the present act. And therefore, I think intervention at the level of central government was very much required. By proposing such amendments, the central government certainly not interfering in following any particular faith, nor the central government is prohibiting any Muslim, any person from donating his property towards a charitable purpose in the name of his religion. But as we are living in a democratic country which is governed by the rule of law, accountability of all the institution is of prime importance. When all the institutions, including our own judiciary, is accountable, then why not work tribunal, work board be made accountable towards the citizen of this country, citizen of this nation. As pointed by Advan sir, even government properties were shown as the property of Waqf. So finally, the central government has come with some provisions so that a common man, a common person following any particular religion, particular faith would get benefited. Then a question arises, why such hue and cry? See, this is not a hue and cry on a particular amendment. This is not a hue and cry over any particular bill. These people are well aware that this is the last battle for them. What we can say in Marathi, आता ही त्यांच्यासाठी बालेकिल्ल्याची लढाई झाली आणि बालेकिल्ला वाचवायचा असेल तर कोणत्या ना कोणत्या कारणाला समोर घेऊन देशभरामध्ये एक अस्वस्थतेचं वातावरण या लोकांना तयार करायचं आणि त्या या वक्फच्या निमित्ताने किंवा अजून येणाऱ्या काळामध्ये कोणत्या ना कोणत्या निमित्ताने अशा प्रकारचे अस्वस्थता पसरवणारे विषय हे लोक समोर आणणार आहेत. आणि त्याच्यामुळे we can say these amendments would amend entire scenario. These amendments would amend the administration of justice for a common person who is following a particular faith. It would amend everything for the person who is donating his property in the name of religion, expecting it to be used in the name of religion for the welfare of religion. So with this, I conclude by saying that in all this battle, with the guidance of our senior karyakartas or elderly office bearers, we will certainly proceed and we will certainly win. A day before yesterday, our Home Minister has assured the entire nation that in coming parliamentary session of Parliament, winter session, this bill, proposed bill, would be certainly cleared in both the houses. With this, I conclude. Again, thank you very much. Thank you for giving opportunity to all the office bearers of Adhivakta Parishad, Devagiri Prant.
Thank you, sir. I now request Advocate Yugandhara Namde, Sahamantri, Adhivakta High Court Unit, Chhatrapati Sambhajinagar, to propose the vote of thanks.
Thank you, Soham. Namaskar to all the esteemed Adhivakta members. On behalf of Akhil Bharatiya Adhivakta Parishad Devgiri Pranta, I, Advocate Yugandhara Namde, Sahamantri, Akhil Bharatiya Adhivakta Parishad High Court Unit, extend my heartful gratitude to Advocate Shrikantji Advan for enlightening us on registration of Waqf. I would like to thank President of today's lecture, Advocate Parijatji Pandey sir, for concluding today's lecture. Now, I would like to thank Advocate Sanjeevji Deshpande sir for guiding us. I further extend my gratitude to Advocate Sangeeta Bagul madam for organizing today's lecture. And last but not the least, I would like to thank Soham Khambete and all the audience. I declare that today's lecture is concluded. Thank you very much.